Ready? Start. No doubt it is not a case of second marriage but deals with standard of proof under section 125 Code of Criminal Procedure by the applicant to prove her marriage with the respondent and was not a case of second marriage. Stop. However, at the same time, this reflects the approach which is to be adopted while considering the cases of maintenance under section 125 Code of Criminal Procedure, which proceedings are in the nature of summary proceedings. Stop. No doubt the division bench of this court took the view of the matter needs to be considered with respect to section 125 Code of Criminal Procedure by larger bench, and in para 41 three questions are formulated for determination by a larger bench, which are as follows. Stop. Whether the living together of a man and woman as husband and wife for a considerable period of time would raise the presumption of a valid marriage between them, and whether such a presumption would entitle the woman to maintenance under section 125 Code of Criminal Procedure. Question mark. Whether strict proof of marriage is essential for a claim of maintenance under section 125 Code of Criminal Procedure, having regard to the provisions of the Domestic Violence Act 2005. Question mark. Firstly, the parties had been living together for a long time, and on that basis question arose as to whether there would be a presumption of marriage between the two because of the said reason, thus giving rise to claim of maintenance under section 125 Code of Criminal Procedure by interrupting her. Stop. The court has impressed that if man and woman have been living together for a long time, even without a valid marriage, as in that case, term of valid marriage entitling such a woman to maintenance should be drawn, and a woman in such a case should be entitled to maintain application under section 125 Code of Criminal Procedure. Stop. On the other hand, in the present case, respondent number 1 had been able to prove by cogent and strong evidence that the petitioner and respondent number 1 had been married each other. Stop. Indeed, a Muslim father can claim custody of the children born through the divorced wife to fulfill his obligation to maintain them, and if he succeeds, he need not suffer an order or direction under section 125 Code of Criminal Procedure. But where such custody has not been claimed by him, he cannot refuse and neglect to maintain his minor children on the ground that he has divorced their mother. Stop. The right of the children to claim maintenance under section 125 Code of Criminal Procedure is separate, distinct, and independent of the right of their divorcee mother to claim maintenance for herself for maintaining the infant children. Stop.